Hello, good evening. See, after the independence of India in 1947, we all know that there were lots of issues which had to be dealt because ultimately the country was opening its eye in a different kind of environment after that. And how the country will run, how the government should function, how people should behave in a society. There are lots of issues which were to be addressed at that time. And to take all these things into account and lay down the policies, the rules, and all those things, a constitution committee was framed, which was led by Dr. B.R. Ambedkar sir, who is called the architect of our Indian constitution. When this constitutional committee was discussing, deliberating, and working hard on these aspects, there were lots of issues. And among all those issues, there was one very important and pertinent issue which still exists and discussed at various forums, was how the people, those who are deprived of even basic facilities, basic amenities, and a class, division in class was found in society. Social discrimination, normally when we call. And this social discrimination was based on caste, means predominantly. This was one of the factors, and that has been mentioned by various authors in the literature. Even Dr. B.R. Ambedkar, because of those factors, he decided also to take appropriate measure for himself. So this social discrimination was something which was very pertinent, visible, and it was very important that our constitution should have specific provisions to deal with these issues. Uh, and this must have been one of the biggest challenge before the people those who were looking into this. In your opinion, uh, how our Indian constitution uh, deals with this social discrimination to provide equal opportunity to everyone? Uh, what are the specific provisions? Could you throw some light on this?
Definitely. If we talk about social discrimination, basically the inequality that is existing in the society, it was not something that was seen before independence in 1950s or after independence in 1950s or before in 1930s and 20s. This is something which is continuing from, if we see history, this is something which is continuing from Indus Valley civilization. If we throw a look back there, then we see different types of burials, some burial having many goods because they definitely believed life after death. So some were having many goods and ornaments. Some had just a mere handful of grains or some eatables, some had nothing. Then, if we jump to the Vedic era, like later Vedic era, early Vedic era, there the society was divided into Aryans and non-Aryans. Later, which was divided into four Varnas, like Brahmanas, Kshatriyas, Vaishyas, and Shudras. So earlier, the concept of this classification was totally different as compared to what we see today. But we very often hear these names even in today's society also. So, coming back again to the era of independence, where the constitution was being framed, how the uh, obstacle of social inequality was dealt. So, Bhimrao Ambedkar, who is considered as the one of the father or architect of the Indian constitution, while he was in his schooling, while he was studying, he faced many problems, like he was not allowed to enter into the school, or if he was allowed, he was asked to sit outside the classroom. But no doubt he was a brilliant student. So Maharaj of Baroda, he recognized his talent and he gave him a scholarship that, okay, you go study from abroad, whatever you want to study. But you promise me you have to come back again to India and you have to work for me. So, as per this deal, B.R. Ambedkar promised him. He completed his studies and he came back to India. After that, the few after few years, the formation of constitution started, the independence struggle started, and one of the major problem that was seen was social inequalities. if we see our constitution today, how it evolved and how the articles laid in it, then Article 15 deals with the inequality. Rather, we must say deals with some special provisions and protections for the ones whom we consider today a little social unequal or socially backward. So 15 clause 1, if we talk about it, the article 15 clause 1 says that government and the state, they cannot differentiate between people on the basis of caste, religion, sex, their place of birth, and all these things. 15 clause 2 says that not only state, 15 clause 2 talks about any private body cannot discriminate among the people. For example, if there is a temple in a locality, people cannot discriminate that people belonging to so and so category, so and so class and caste cannot enter to the temple, or they cannot drink water from that public well. Such things are not there. So, first, the clause of Article 15, we say it as a negative right, okay, because the rights in which the state has the authority to interfere and discriminate, they are known as positive right. And the articles, the rights in which state is not allowed to discriminate, that is known as a negative right. So basically, what was needed in the society was equality. That was a major issue at the time. But what our Indian constitution follows is the funda of equity, not equality. We do not follow equality. Equality means treating everyone equally, and equity means treating likes alike. Say, for example, if I am earning 1,000 rupee per month, my colleagues are earning 10,000 rupee per month, and we need 15,000 rupees to purchase something. It will be useless to give 15,000 to me also and 15,000 to my colleague also. Rather, what the government will do, he is already having 10,000, he will be given 15,000. I am having 1,000, I will be given 14,000. So this is what our constitution follows. Now, if we come to 15 clause 3, it talks about special provisions for women, like some guidelines, some which is not clearly mentioned, because we have heard a very famous case of Bhavari Devi. And the case, it is a sorrow, kind of sorrow, that the justice is not yet being given, but a very strong action, a very strong declaration that was given for that case was Vishakha guidelines, which are very common and very prevalent today. So this is what all about our constitution provides for the protection, for the equality of the socially backward ones, we can say. So this was all about Article 15 that deals with it.
Yes, wonderful. Uh, this, the- in fact, the Article 15 what you mentioned, it talks about uplifting the people who are socially discriminated to provide them opportunity so that they can also participate equally with the rest of the class of society. How does it addresses the issues related to education? But this is also very important. And if we want to take certain segment of society which is considered to be socially deprived, until unless the education is provided, the thought process will be limited. They may not have that kind of understanding and thought process which is expected of them. So, how this education is dealt in Constitution of India, especially for these segments?
If we start with education, then the first case, the idea of providing special privileges in education, special provisions in education, started in the year 1951 from Champakam Durai Rajan case. Because till the time, government has said that special provisions, affirmative actions to be provided for the socially backward ones, because which was basically termed that as reservation, we commonly hear today. So, Champakam Durayarajan case in 1951 was the case of Champakam Durayarajan versus the state of Maharashtra, Madras. What happened? Champakam Durayarajan gave an exam for admission in a college, and the college, she got a very good marks. Definitely, that was a good score, but she failed from 1 mark, and this was given to a socially backward or unequal class, and she was deprived from that seat, for which she filed a case in the Supreme Court. And she said that, okay, you are giving right to the socially weaker one, but what about my right? She said that you are giving them their fundamental right, but what about my DPSPs, my directive principles of state policies? And before 1951, there was a judgment in which the government said, in which the Supreme Court said that fundamental rights and DPSP, they cannot overcome each other, and there need to be harmony between them. Whatever decision we take, there has to be harmony between the two. So, likewise, the case continued, and finally, we reached to a conclusion which was mentioned in the First Amendment of the Constitution that was done in the year 1951. So, the policy of this said that the policy of reservation cannot be given because DPSP and fundamental rights, none can overcome each other. Then again, a series of cases were held for the same thing, whether reservation should be given or not given. Then came Article 15, Clause 4, which said that nothing in the article can stop the state from giving reservation. That state is free to give the reservation, and the idea of reservation was added in the ninth schedule of the Constitution. Then slowly and gradually again the problems they started coming up because 15 clause 1, 2 and 3, they were implemented in 1950, and 15 clause 4, this was added with the amendment in the year 1951. So what happened, the problem that was arising here was some state were giving 68% reservation, some were giving 72% reservation, some were giving 80% reservation. So the condition was that their population is in minority, but they are getting the reservation more than 80%, more than 90%. So this is a positive discrimination with the socially backward, but isn't it a reverse discrimination with the general category or the ones belonging to a better good condition? So then Supreme Court said that we will be following a concept of 50% ceiling, which said that any state cannot give the reservation more than 50%. They cannot breach the criteria of 50% reservation. Then we had Balaji case. M. Balaji case was held again for the same issue, and as we see, various amendments were held. Article 15, Clause 4, it was once again challenged. Once again, the Supreme Court gave the same judgment. And in 1962, near about somewhere in 1962, OBC reservation, other backward classes were also recognized. So the condition that was arising at the time was in the other backward classes, first of all, we divided two classes, that was scheduled caste and scheduled tribes, that they need reservation, they need affirmative actions and special provision for their upliftment. Then came the difference that do we really need to discriminate or provide reservation on the basis of caste? Because what B.R. Ambedkar said, what our Constitutional Assembly said, was there was a difference between class and caste. The main focus was class, which meant that socially unequal in the sense of poverty, income, place of living, standard of living. But here, what we were following was something else. So, this was once again challenged over there. Then slowly and gradually the Supreme Court gave the judgment, and finally we came to closure of the case with Article 15 Clause 4, which said that reservation in education is definitely important and needed, but it should not be a permanent situation, right? We should follow the reservation for some year, and the only motive of following the reservation should be eliminating the reservation, so that one day we come to a level where the deprived ones reach the equal level and take the same profits and benefits that the already upper class, not upper class, but the ones who are financially stable are taking. So this was the case that was held for basically in education purposes.
Uh, when this the education, we talk about the education system, there are government institutions, there are private institutions too. And the statistics shows that around 65% of enrollments are in private institutions. So they're a big player in providing higher education or school education, if we take. Now, whether this protection, which we call reservation, also applicable to the private institution and how it deals with.
If we talk about private institution, then again we have a series of cases because polity and its judgment are incomplete without cases and Supreme Court's judgment. So this problem arose during 1980s. The situation was government colleges were giving their reservation. They were following the article. They were following Article 15 clause 4. Then certain case came up. They started coming up. Cases started coming up. One of the most famous case was Mohini Jain case. Mohini Jain case, it took place near about in 1980s, somewhere in 1980s, or rather, if I mention to be precise, if I have to be precise with the year, it was 1992, and it was three judge bench. After the Mohini Jain case, we had Anni Krishnan case. After Anni Krishnan case, we had IMA Pi, TMA Pi Foundation case, which was a very famous case, and in which the government said that private colleges, they need to help the government. They need to give their contribution because nation is not only of government, nation is not only of private colleges. So even private colleges need to give their contribution to reach a position of social equality in the society. So private colleges, they were asked to give some reservation. After the reservation, some of the private colleges, they again came up with a complaint that as per Article 19(1)(g), we have the right to earn profit, we have the right to do trade, to help our own self commercially. But since the Supreme Court is limiting our right, and the Supreme Court is saying that what we need to do is to give reservation, is it not breaching our right, our fundamental right of 19(1)(g), on which the Supreme Court said that the unaided private colleges, they do not have to give any reservation, because Supreme Court showed a little on humanitarian ground. Supreme Court said, okay, fine, the unaided one, they do not the reservation. But again, few cases they were coming up, and final judgment of the Supreme Court came up saying private colleges need to give. They don't need to give reservation, provided they cannot take donation. They, like some of the private colleges at the time, were taking donation fee. So Supreme Court said, okay, but you cannot take donation. Fee should be limited, and Supreme Court it fixed certain criteria for the private colleges as well. Then again, series of cases were there. We have Inamdar case, and final judgment, final verdict of Supreme Court came up that private colleges, they need to give certain reservation on certain basis, and which was not mandatory everywhere. But the minority private colleges, for example, Khalsa College, they will have their own set of reservation criteria. For example, Muslim University, they have 50% seats reserved for the Muslim candidates and 50% open to all. For example, Khalsa, they have 50% seats reservation for the Sikhs and 50% open to all. So likewise, this was the case when we come to the private colleges. And just because of this condition, when private colleges were forced to give the reservation, till 2002, we see a year, 5 years, which is known as dark year of for private colleges, in which no private colleges were open in India. Just because private colleges were forced to give the reservation, because the main motive for them at that time was to earn profit, to do commercial purpose, and they were deprived from that right itself. So later on, Supreme Court, it showed some liberation. It gave them some flexibility, and finally, today we are seeing the condition. What?
See, one, the deprived section of society and its education, uplifting their status so that they also come at par other segment of society which were